Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Our today's case is relating to the interference of the police in civil matters, which is prohibited under APPM Order number 322, Sub-Rule 1, that is Police Manual, as well as the CRPC and also the Civil Procedure Code. Normally, according to section 154, whenever a cognizable information is received at the police station, so the police have to register a case and they have to investigate the matter. As regards non-cognizable cases, they have to resort to the procedure laid down under 155 CRPC, but they should not interfere in civil cases. This is the rule. But still, they interfere in the civil cases, and it has got a lot of impact on the acquisition of the sites, on the transfer of sites, on the transfer of lands also. So in this connection, in 2010 itself, Justice C.V. Nagarjuna Reddy, now he is retired, so he has given a beautiful judgment and he has asked the DGP to issue some frame certain guidelines to the police not to interfere in the matters of the civil nature. So we will discuss such case. So you can refer this case as Srimati Farhat Begum, Farhat, Farhat Begum, wife of Nasiruddin, right? Represented by Nasiruddin Hashmi, represented by the GPA holder Chandra Babi Abbas versus the Inspector of Police Humayun Nagar Police Station, Hyderabad City, in WP number 5473 by 2010. So the judgment came on 10/11/2010 while disposing this writ petition of that is writ petition for mandamus or some direction they have given, right? So while disposing this thing, if you go right, clearly Justice C.V. Nagarjuna Reddy stated that police interference in civil disputes, so definitely it is deprecated. There should be some remedial measures. For that only this judgment you have to read. So before reading the judgment, let us go into the details of the case. That's better. Alright, Srimati Farhat Begum, she has got a certain site. Actually, this is a house site in Humayun Nagar. Right, so this is located in survey number or things like that they have given. It's not that important for you. So he has the owner of property in let us discuss the door number 10-3/299/4 in Humayun Nagar PS limits, right? So but some of the relatives they wanted to occupy or they wanted to encroach the land. Therefore, he approached the civil court, that is 10th Junior Civil Judge Court, and obtained an injunction order in IA number 13/2010. So, while the injunction was in force, this woman, Srimati Farhat Begum, of course, she did not come. Actually, the GPA holder was summoned to the police station. He was summoned to the police station. The CA of Humayun Nagar PS, right? So he called him and gave him a stern warning that if he does not allow the relatives of the other, that means the accused persons, if he does not allow them, then definitely a case will be registered against him. So afraid of this, he approached the Honorable High Court to issue the writ of mandamus. So this the thing happened. Actually, now you are clear. He is the GPA holder for certain land. They wanted actually to dispose the same, but the relatives have occupied the same. When he objected for the same, then they might have filed a criminal case against him. Now the police have interfered and gave a stern warning to Chandra Babi Abbas. Right. Now he has filed a writ petition before the court. Of course, as usual, the court asked for the affidavit of the police. The police stated that, right, so the relatives of this Farhat Begum, that is who wanted to occupy the land, they have filed a case against him that these people, they have wanted to trespass into their land. They have trespassed the land. They have come there, 452 also there with deadly weapons. They occupied the same with deadly weapons. Therefore, the police registered a case in crime number 24/2010 under sections 448, 352, that is assault, 341, 506, criminal intimidation, read with 34 Aphc, and it is in progress. Now the police have taken the defense that they have registered a case and the case is under investigation. So court clearly stated, noticed that not only this, there are innumerable complaints of police interference of this nature coming to the court in the shape of a writ of mandamus. Therefore, Justice C.V. Nagarjuna Reddy impleaded the DGP of Andhra Pradesh, I am talking about combined Andhra Pradesh, as a respondent and asked him to revise or to give instructions to the subordinate officers in the entire state not to interfere in police in civil matters. If they interfere, if the persons have got any grounds, then where they have to report. So regarding this, some framework has to be prepared. That is why he has implemented the DGP as a party. Of course, as a response to this, the DGP, on the recommendation of the DGP, the state of AP has issued a GO MS number 288 by home, within bracket PS and PCA2, okay, dated 6/11/2010, right, dated 6/11/2010, stating that the High Court of AP is serious over the interference of the police in civil matters, and therefore they should not at all interfere in the civil matters. And for this, a committee has also formed. So suppose if it is in ranges, the range IG will be the chairman, SP will be a member, and the officer of special duty, OSDs, they will be another member. These three people have to decide whether the police interfered in the matter or not within 15 days, and they have to send up the report, and of course after the report, department action can be taken. Right, so this is the methodology they have evolved by the police. And here already I told you, APPM order number 322 sub rule 1 says that police should not interfere in civil matters. Of course now APPM, I think orders might have changed, right? Then this now Justice Nagarjuna Reddy added some more points to this, and the GO has been issued. So as per the court, the additional points of the court are like this. Number 1, the general public should be made aware, or publicity should be given to the general public on this GO, that police will not interfere in civil matters. Number 2, a notice in the police station should be affixed stating that if anybody is actually having any grounds that police interfered, then they can report the matter in the particular proforma, and the proforma has to be displayed in the notice board also. And you can, the police can say that the complainant can come and straight away put it in the drops box, because if it is known to the local police, they may be agreed with him. Last point is, if he is not allowed to the PS, or if he doesn't want to the PS, come to the PS, yes, he has got a chance to approach the superintendent of police. So the complainant can be allowed to meet the SP if they are not allowed in the PS. There are certain occasions where the police may bother him. Therefore, he can directly go to the SP also. So with this, the course is closed. So what I want to tell you is, this is a specific case where if police interfere in civil matters, you can object stating this, right? So very good judgment. Of course, Mr. Nagaraju Poduli from Poduli, he has submitted, he has sent this case law, and actually I wanted to tell all the people, even for the police officers also, this will be useful not to interfere in the civil matters, right? So please go through the judgment, and definitely you will be enriched of the legal knowledge. Thank you very much.